We are live on Facebook. Kevin, can you please remember to hit record as well? Good morning, everyone. Thank you for joining the Free Rusesabagina team for another press conference to update us on Paul's legal situation and on what's happening with Paul Rusesabagina's case. We will be taking questions at the end of the statements. In order to ask a question, if you look at the bottom of your screen on the right-hand side as you're looking at it, there's a Q&A function. Please put your questions in the Q&A function and we will answer all of them. We are live right now on Facebook and we're recording this. So if you talk to any other journalists or friends who want to watch this, they can always go to our Facebook page and tune in. My name is Kitty Kurth and I work with the Free Rusesabagina movement. I'm now going to turn this over to Brian Endless. Brian, can you get us started talking about the most recent legal issues, please?
Absolutely. Thank you, Kitty, and thank you to everyone for joining us. As Kitty mentioned, my name is Brian Endless. I'm a professor at Loyola University, where I'm Director of African Studies. I've also worked with Paul Rusesabagina for 15 years, and I'm now working with his family and the team to free Paul Rusesabagina from prison in Rwanda. On August 28th, 200 days ago to the day, Paul Rusesabagina was kidnapped from Dubai and brought to Kigali, Rwanda against his will. He had been lured there from his home in San Antonio by an agent of the Rwandan government and drugged while on the plane so that he would not know where he was going. For those who know Rwanda, it was clear from the moment of Paul's abduction that he would never get a fair trial. Paul is a frequent critic of the human rights violations of President Kagame and his regime, and Kagame has publicly vowed to silence Paul on many occasions since the release of Hotel Rwanda in 2004. This has included harassment, threats against his life, raids on his house, and now has culminated in his kidnapping and imprisonment. We're here today because last Friday, Paul Rusesabagina stood up on day 5 of his trial and said, enough. His rights to what the rest of the world would deem a fair trial have been violated every single day since he was kidnapped, and this has only been worse since the trial began on February 17th. Paul made the decision to step away from a show trial put on by a dictator who treats all dissidents as criminals and who has tried, convicted, imprisoned, and many times killed anyone who speaks out against him. Paul's statement to the court and to the world was simple. In his words, and I quote, "I'd like to tell the court and the judges that my basic rights to defend myself and to have a right to a fair trial were not respected by the court. Therefore, as my rights have been violated, I'd like to tell the court that I don't expect any justice in this court. And so I want to inform you that I will not be appearing again in court for the hearings. I have stopped my trial," unquote. We're here to tell you today that many world leaders have been calling for a quote unquote fair trial since Paul was kidnapped. But we need to let the world know in the strongest possible terms that this must change. President Kagame has prejudged Paul's guilt in public, and it is crystal clear that the judges have no independence at all. In addition, human rights groups have reported for years about the Rwandan government coercing confessions from prisoners to get whatever result they want out of a high-profile trial. And in this case, we have already seen that all of Paul's co-accused, most of whom he has never met, will testify against him as they are told to. We are very pleased that the American Bar Association and Clooney Foundation put out a pre-trial report showing the incredible lack of fairness before the trial even began. This call was echoed by the International Bar Association, as well as the Lantos Foundation and the Edelstam Foundation. The European Parliament recently passed a resolution clearly stating that the kidnapping and trial were unfair and illegal, and that Paul should be immediately released. And members of the US Congress published a bicameral, bipartisan letter in December calling for Paul's release. On behalf of Paul and his family, we now need the rest of the world to join these calls for Paul's immediate release. In particular, this includes the Biden administration, the State Department and Congress, as well as the Belgian government. One immediate step that can be taken, we urge the US State Department to immediately implement the new Khashoggi ban, which allows them to place visa restrictions on any and all Rwandan government officials and their families involved in Paul's kidnapping. The Rwandans have proven that this will not be a fair trial in any way and have denied Paul's rights on a daily basis. It is now time to increase the pressure on that government to bring him home. At this point, our plan was to have one of Paul's international lawyers, Philippe Larochelle, join us. And unfortunately, Philippe is in Arusha, Tanzania, and is unable to join the call for technical reasons. Hopefully, we'll still be able to get him in. We were going to ask Philippe to do a quick overview of the abuses during the trial process. If everyone can give me a moment, I'll quickly go through those and then we can discuss them in Q&A too.
Yes, Brian, we're hoping that Philippe will be able to join us in a few minutes for the question and answers. But if you can run us through the legal violations, the fact that we're still waiting for pretrial motions to be heard, et cetera. And then we'll open for questions after you go through the basics of what's happened.
Absolutely. Thank you, Kitty. Paul raised a variety of different violations in written and oral pleadings pre-trial that would have allowed him to prepare a real defense. When the trial started on February 17th, none of these motions had been dealt with. And as we moved from February 17th to last Friday, we realized that the Rwandan government was simply dismissing any possibility of a fair trial over and over. Our lawyers have said multiple times, it is difficult to imagine criminal proceedings that are further removed from impartial justice, that are further removed from a fair and legitimate trial than those that are happening against Paul Rusesabagina in Rwanda. On the charge of kidnapping, the Rwandan government, President Kagame, the Brigadier General in charge of Rwandan military intelligence, the Justice Minister, and the star witness for the prosecution, who was the informant who lured Paul to Rwanda, have all made public statements or taken the stands confirming that Paul was kidnapped. He was brought from San Antonio via Chicago to Dubai, and in Dubai, he was put on a plane that went to Rwanda. He did this because he was lured by a publicly accepted agent of the Rwandan government, someone who was working directly for the Rwandan government. And we just found out recently that while on the plane, Paul was drugged. This was both luring and force. I actually see that Philippe Larochelle is joining us.
We're going to give Philippe just a minute to get himself together. Bob, I wanted to ask you that the issue that Brian mentioned briefly about the plane. One of the other things that's happened in the last couple of weeks since we've done a press conference is we saw that Al Jazeera video of the Minister of Justice talking about what happened with GameJet. And I'm wondering, Bob, if you could just talk a little bit about that and about the remarkable nature of the video while Philippe gets settled.
Sure. This is Bob Hilliard. I lead the team on the civil litigation on behalf of the family and Paul against GameJet and the bishop who lured him. The video that Kitty was referring to confirms what we allege in the complaint, and that is Gainjet was complicit. Gainjet was told beforehand that this was going to be a active, aggressive, and punitive kidnapping. They agreed to participate. They were paid by Rwanda, the government of Rwanda, to participate, and they were successful. So though the video is compelling, you know, it's the old saying, you know what you already know. You know, we knew that that was the case. We expected the evidence to come out through the litigation. We were surprised only in how early it came out, but not by its content, because there's no way you can put someone on a private charter, drug them, tie them up without the pilots who, in that long a flight, just by human nature, have to walk through the cabin to the bathroom in the back, which is what you do in a Challenger, the type of aircraft, and not know what's going on. So it increases the strength of the civil litigation. And keep in mind, since it's not a criminal litigation, a criminal prosecution, the burden of proof is less. And we have filed the lawsuit in a very fair court in the Western District of Texas, where Paul lived. And we expect that that once service is successful, and the lawsuit is already out for service right now. In other words, it took some time under the Hague Convention rules to get the lawsuit translated into Greek, and then get it to a process server. And now we are going to serve the entity and have them be required to come to Texas and appear and either protest the venue or defend the action. And my guess is they'll do the first, but can't do the latter ultimately.
Thank you so much. And now going from a court where we're playing by the rules and going through the actual legal motions, Philippe, can you take us to the other half of the world where there's a trial going on, but they don't appear to be following any normal trial rules?
Yes, of course, Kitty. I apologize. I was in let's find out. You know, we'll find out soon if it's fair or not. A court in Arusha, and they just changed the hour, I think. So I thought I had an extra hour. So I apologize for showing up here the last minute. I understand that Brian spoke about the kidnapping. There's not a moment of this trial that can be defined as fair, from even before it started, when it was planned in the offices of the RIB, the Rwanda Investigation Bureau in Kigali, up to this day. Every step along the way is a case and study of unfairness for a trial. So the kidnapping, I think Brian covered, but I think what is amazing about this kidnapping is that it's wrong in international law, but it's also wrong. The interesting part is that we're having discussions with the Rwandan lawyers who are coming from the civil side, and whatever way you look at it, a court cannot continue proceedings that start in such with such egregious violations of the accused's rights. It is just it's just unbelievable. And the first questions that comes to mind is, if they are confident and think that they have such strong evidence against Mr. Rusesabagina, why not use proper legal avenues to obtain his extradition? Why not do what every civilized country and what normal criminal proceedings entail when you want to accuse somebody who's in a different jurisdiction, which is introduce proper extradition procedures and explain why the person targeted by these procedures should be removed from where he lives and should be brought to another country to face justice there for crimes he's alleged to have committed. There's nothing of that here. There's just ruse and force to basically remove him from where he lives and bring him to Kigali without his consent, without any proper proceedings, and nothing of the sort. So brought to Kigali, then tortured for a few days, gagged, bound, and then after that, two lawyers are parachuted who claim that they were representing him, but who actually never brought the issue of kidnapping before a judge. Never. never opposed taking statements on his behalf in view of the conditions in which he was taken to Kigali. So these two lawyers were basically subdued and playing in the hands of the Kigali regime to make sure that Paul could not make legal challenges and raise the proper legal issues and the dire circumstances in which he found himself arriving in Kigali. So that, for them, for the Kigali regime to have skillfully placed these two obedient lawyers at the side of Paul was a sure way to ensure he would remain silent, and it would be difficult, as I said, to raise these legal challenges, but also time elapsed. So there was nothing about getting his case filed. There was not the usual litigation that surrounds the beginning of criminal procedures about the indictment, about disclosure, about all of these normal things that a criminal lawyer would do when a criminal trial starts were never done, which with the effect that later down the day, when some of these issues were raised, the reaction of the prosecutor general was that to say it was too late. I remember perfectly this tweeter of one representative of the Office of the Attorney General claiming that it was now too late to raise the issue of kidnapping because too much time had elapsed since that happened, which is just absolutely fantastic. From there to what? From there to having to fight for several weeks to have the lawyers you want at your side. So that's what happened. So after several weeks, we are now in October, before he has the first contact with the lawyers of his choice, Maître Gatera. It took weeks before that happened. And in the current conditions where COVID severely restricts access to the prison, where he's given a few minutes per week of telephone contact, and he has to decide whether he wants to talk to his wife and kids or whether he wants to talk to his lawyer in those very limited time that is allocated to him in order to have access to the outside world. So you can imagine even that, this confinement, this after having been kidnapped in the conditions we have described, and then being cut from the world, literally, for many weeks and months that followed. Eventually, a lawyer is appointed, but not all the lawyers he wanted. The team of lawyers he wanted were made of a local lawyer, but also of international lawyers. In a dictator like Rwanda, lawyers are we have to salute the courage of the lawyers who dare fight in the courts there, because it is a very difficult position to be in, especially when you know very well that there may be consequences of bringing before the judges the political side of this trial, which was where we see that the political authorities of Rwanda clearly were implicated and were actually commenting on what had happened to Mr. Rusesabagina. So it took some weeks for these lawyers to be able to get there. And once they got there, they had very limited time to actually discuss with Mr. Rusesabagina. And then all of a sudden this trial starts with all the conditions. You could tick all the box of unfairness easily, no time. Let's just put it that way. Last week, the trial started. Last Friday, the trial started on Friday. They put the first witness on the stand. 2 days before, the same court that started this trial on Friday had decided that he needed a computer and that he needed to have access to his case file. And what was the evidence that they needed a computer and needed access to his case file? These judges themselves had visited him in prison and could see for themselves, discussing with Mr. Rusesabagina and his lawyers and the prison authorities, that he did not have access to a computer, that he could not have access to his case file. And the decision of the judge is based on evidence that they had seen with their own eyes about the fact that he did not have the proper tools and the proper time to start his trial. Do you think that stopped them? 2 days later, they brought the first witness on the stand. And so this testimony, that first witness that took the stand, this was done with the court fully knowing that this accused did not have any of the case file, did not have a computer, and did not have 5 minutes to prepare confronting the very severe allegations that are made against him. And the beginning of this trial last Friday followed weeks of intense litigation where these issues were raised before the court. The issues of proper legal representation, the issues of access to the case file, the issues of having the proper tools and time to prepare his trial were raised in multiple instances and were even appealed. But the only possible and reasonable inference to draw from what happened between Wednesday and last Friday is the dreadful phone call from the authorities to these judges, because no sound legal mind could make a decision like that and take a decision like that without interference from powers from above, let's put it like that. And what I failed to mention also is that before this decision was rendered that Mr. Rusesabagina did not have his case file, there was also intense litigation about the fact that the prison authorities had no respect or consideration for the privileged documents that he had received, for all the documents that he had received. These were systematically confiscated so even memos, preparation for his defense, were systematically confiscated by the prison authorities, and they admitted that when the judges went for a visit on 5th of March and asked about this because it was raised in the procedures. There were admissions from the prison authorities that they were confiscated everything and not giving back everything. So Mr. Rusesabagina for all these weeks was in a position where he had no access to the case file, but also no mean to instruct his lawyer, to receive instructions from his lawyer, to exchange about the proper strategy to adopt in view of the upcoming trial. And I've seen trials going in several countries, in several jurisdictions. I have never seen something like that, never. And even in Rwanda, where they're not not well known for the quality of their justice, this is even taking it a couple of notches above what I've ever seen in that country. And so for all these, taking all of that into consideration, I was relieved when I saw him walk out. I thought he had given them so much opportunities, so much time, and so much, he made so much attempts at trying to correct the situation and trying to help them make this try to turn this into something, that may at least be called fair. That never happened. So I salute his courage. I was proud and saddened at the same time, because as a lawyer, this is the ultimate thing to do, and to not to be in a position to engage and to contest what we have already indications are completely fabricated and manufactured evidence, as it's so usual in that country, is not an easy call to make. But I think that in the position where he found himself, there was no option. There was no other choice, really.
And I think you mentioned this briefly, but I want to emphasize it because I think it's such a universal thing. They took lawyer-client privilege documents, which I think even by Rwandan standards, that went over the top, right?
By any standard, maybe except North Korean ones, taking confidential and privileged lawyers' document is completely unacceptable. They have no respect for law, for the respect of these things that we take for granted, actually, And yes, it was done on a regular and on a regular basis. The documents brought by Mr. Gatera, prepared by us, Maître Gibson, Maître Choaris, and myself, for Paul's consideration and to assist him in preparing the trial, they were confiscated.
And isn't it normal in the Rwandan system that the first thing that would happen in the trial is that the indictment would be read out loud? And on Friday, yes, they just started without reading the indictment, correct?
What they did not read the indictment. And I want to say also that this witness was unannounced, and the other witness too, the bishop, completely unannounced. They are waiting behind the curtains of the courtroom, and the prosecutors take them out of his bag without any prior notice to the accused. I mean, normally, you know, you have a batting order. The witnesses are announced in order. You know who's coming and when. You know what evidence will be presented. But even before you do that, you ask the accused, "Are you pleading guilty? What is you understand?" And then the prosecutor normally make an opening statement. All of these things. This trial is a circus. It's a real judicial farce, really.
But Philippe, I understand they did give Mr. Rusesabagina a desk and a shelf in his cell.
And you're right. And upon the visit, this was part of the minute of the visit, that he had a shelf to prepare. Unfortunately, there was no case file to put on that shelf.
Exactly. I'd like to open the floor up to questions from the journalists, questions from the audience, if there are any. Or Anais, did you have anything you wanted to add before we go to questions?
No, I don't have anything to add. I think Brian, Bob, and Philippe said everything very
Then-
well. What I will just add is just I was very proud. Our whole family was very proud of our father for standing up for his rights and for taking up for his principles. And that keeps us going and motivates us to continue as fighting for his release. But he did the hard work over there, so we just have to continue what he's been doing.
Philippe, the first question is about process. We've said that Paul has stopped the trial. Do we know what that actually means, or what that's actually going to look like? Do we have any idea what's going to happen on March 24th when the trial is slated to commence again?
Well, thank God, this does not happen every day. So it's very difficult to play out how this is going to be. This is going to unfold now. Several scenarios can happen. They can appoint. Maybe they will rehire the two lawyers that they used at the beginning to make sure to silence him, and they will come back to the court. What will happen? Will they bring him by force in the court, or will they allow him to act as he wish, which is not to attend or participate in these proceedings? Will they give specific instructions to the lawyers? At this point, it's very difficult to predict. The two witnesses that appeared in court, in both instances, there were no prior notice. There were no indication that they would bring witnesses on these days. So as far as predicting what will happen, we can just say that, the unfairness will continue. But as I said, they've been, I mean, let me get back on this because I think it's important. The first witness that appeared, the court was discussing the issue of kidnapping. And the prosecutor wanted, for some reason, to demonstrate that there was no use of force, which doesn't really matter, as in any case, whether it's force or a ruse, kidnapping. If you bring someone into a car, by disguising the car as a cab to kidnap him, there's no force involved, but the ruse still, brings that person against his will where he doesn't want to go. So the issue of kidnapping was, and there was this insistence to describe to the judge the fact that the kidnapping had not been done by force. So they brought this crazy character, the bishop, aka informant of the court. This guy was brought to the court with no notice whatsoever of anyone. And then the lawyer and Mr. Rusesabagina did what they have to do, which was to object of this parachuting of an unannounced witness in the courtroom. The court deliberated for 1 hour and came up. It's sometimes, when they want to have to issue a decision. What did they do with that problem? Well, we will hear him, but we will not have him take the oath. So there you have the unsworn bishop with sunscreens in the courtroom making a big show and showing what a charade and circus
Is
this
this
court was.
ever a thing in real trials, that a
No,
witness would come in and not take an oath?
I've never seen something like that. And I was so relieved when they refused to cross-examine that man.
Yeah, so irregular by any standard, even Rwanda. Okay. The next question we have is a really good question, and I think the answer is an evolving answer. So Brian, I'm gonna let you start and Anais, but the question is, what is Belgium's position? And I think part of the answer is we're waiting to see what Belgium's position is, and it's a little bit of an evolving thing that we're trying to determine. But Brian or Anais, maybe you have something to add to.
Thank you, Kitty. I'll give a very brief history and then turn it over to Anais. For the first 2 months of Paul's kidnapping, Belgium didn't have a government. They were without a prime minister and without a cabinet, and that very much slowed any answers, and their foreign service just gave basic consular service. The family has been actively working with the Belgian government over time, but progress has been very slow. Anais, perhaps you want to give some of the details on that.
Yes, so the progress has been slow, but we are, hopeful that it will pick up a little bit more because of all the outrageous violations that have occurred in Rwanda. Specifically, we know that there are a lot of MPs who are starting to go behind my father's cause, just like there were some congressional representatives and senators here in the United States. And so we hope that, we can do the same thing they were able to do and request, with the help of the parliament in Belgium, request for the release of my father immediately. We also hope that the Minister of Justice, the Minister of Foreign Affairs in Belgium will also take a stand, given that it's their duty to be working on this issue. We hope that, that will also progress. But we continue to work hard and to see where that goes.
One addition, Belgium also has what is called a rogatory commission that they have been working on, and we're not sure if and when this may go to Rwanda. It would be a group of judges, probably also with Paul's Belgian lawyer, who would go to Rwanda and be able to interview people about the case, and they would particularly be looking at the question of whether the kidnapping was legal or whether, from a Belgian and international perspective, Paul should be sent back to Belgium or the United States. As Phil mentioned, there was no legal rendition in this case. Paul was illegally taken. So we fully believe, under international law, under Belgian law, and under Rwandan law, frankly, that the trial should be stopped based, if nothing else, only on the kidnapping. It shouldn't go beyond that. And the Belgian government is putting together the group to look into that.
And Brian, the next step after the kidnapping, there was also no legal arrest warrant. When you're arrested in Rwanda, there should be a warrant. There wasn't. I just wanted to mention that the European Parliament has a very strong resolution, and we're happy about that. And we think that that may also be pushing Belgium to a little bit of action. But just like in the United States Congress is involved in this and pushing our State Department to act more strongly. And I think in Belgium, there's a parallel process happening that there are several people in the Belgian Parliament who are really pushing the Belgian Foreign Ministry to act. We have another question for Philippe. If there's a rogatory commission in which the Belgian officials go to Rwanda to interview witnesses, how credible could testimony collected be given the level of oppression and coercion that Philippe described? And
the rogatory commission is meant to go see Paul. He was in a criminal procedure in Belgium, and his lawyer in Belgium, Maître Lurquin, seized the judge who was responsible for that file and explained to him that the suspect has been kidnapped. So the rogatory commission is not meant to go meet witnesses, but to meet Mr. Rusesabagina. And more so now that there was a complaint for kidnapping in Belgium. So that's what Maître Lurquin is working on, that the judge who sees of the kidnapping complaint in Belgium goes to visit Mr. Rusesabagina in his prison to obtain all the details and circumstances in which he was kidnapped.
Thank you so much. Seeing no more questions, we're going to wrap up for today unless anyone would like to make a final statement. Kevin is rapidly, no, Kevin, I don't see what you're talking about, but we're going to wrap up for today unless anybody
another
else.
question
Oh, actually, we do have one more. We have one more question. Two questions. The first is really easy. Is Paul getting access to his medicine now? The answer is yes and no. He still has never received his medicine from the Belgian doctors that was conveyed through the Belgian embassy and consular services. He never got that medication. He's being given some medication by the Rwandans. We don't know what it is. They haven't told his doctors what it is. They haven't told his Belgian doctors what it is. One last question. What about the Rwandan law on kidnapping? Philippe Renchens, Brian mentioned it on Twitter. Article 273, according to Rwandan civil law, would it be useful to introduce a complaint based on that article? Philippe, do you want to?
Sure. Article 273 is the old provision. Now it's Article 151 of the Criminal Code of Procedure of Rwanda. The short answer to that is that it's lost energy to introduce a complaint before the courts of Rwanda, seeing how they've dealt with this case so far. The long answer, but the issue of kidnapping was raised before the court, and the prosecutor discussed. The argument of the prosecutor was that it was not kidnapping because it was ruse. The court actually did not dealt on that issue or use that issue to decide whether it was whether it had jurisdiction or not in the end. So for that, it has decided, the court has decided that kidnapping, despite a string of precedents from other courts in the Commonwealth that were clear to the fact that an accused brought by illegal means before them they were not competent to try a person like that. In Rwanda, they have a different view on the matter. The court made sure that it find that it was competent despite the circumstances in which Mr. Rusesabagina was brought before them. So because of that factor also, bringing a complaint for first, the issue of kidnapping now is going before the appeals court. So it's the court is already seized of that, but seeing how they've dealt with the matter in the first instance about the fact that their competence they were not competent because of kidnapping, I think it's a lost cause at this point to hope that they will reverse course and act otherwise, even in face of that kidnapping.
Thank you very much, Philippe. Anais, just clarify quickly about the medicine, and then we're going to go to Brian and wrap it up.
Yes, so for the medication, we know that the Rwandan doctors actually have communicated some of the information to our Belgian doctor, Dad's Belgian doctor, but we don't know the truth of it. We've never had an independent doctor see my father. The reason why I precise that is because until now, the Rwandan doctors have not worked in Dad's best interest. They denied his medication for a long time. So even though that he's sending information to the Belgian doctor, our family doesn't trust it because we know that they're not working in my father's best interest. And we're still requesting and asking for the government to help us get a real independent medical examination of my father since he's been there, which he has not. And so my father still expresses dizziness and headaches. He told us in our last phone call. The fact that he has left the trial, he decided not to participate, the trial comes at a cost. The cost that we might lose our lawyers who see him every day. And that cost is really dangerous because we may not be able to check on him and get his, be to know that he's okay. And that's what Maître Gatera and Felix were able to tell us when they visited him. So for us, for our family, it's a very dangerous period that we're entering now. And we hope that a medical independent examination will happen for my father, because now nobody is going to be able to see him and to verify that he's really okay.
Brian, why don't you?
Yeah, let me close it out here in a couple of things. I think we can start our conclusion by going where Philippe left off. This trial, or this problem, starts with a kidnapping. The kidnapping is illegal under Rwandan law. It's illegal under US law. It's illegal under Commonwealth law. It's illegal under international law. The Rwandans want to go with this popular perception that only force is kidnapping. That's simply not what any of those laws say. Kidnapping is either force or luring someone, or a variety of other ways of getting someone someplace against their will. In addition, under international law, he was brought from one country to another against his will, and that's an illegal rendition in and of itself. Those things should stop this trial cold. More importantly, though, as we continue past that, what we have seen over the past 200 days of Paul's imprisonment is a constant, nonstop, daily violation of his human rights. He has absolutely no chance of getting a fair trial. We've just laid out, Philippe has laid out in legal detail why that's simply not going to happen. There is no evidence whatsoever that this will turn fair. It has been unfair at every turn so far. And we are in a position where, on behalf of Paul and the Rusesabagina family, we need to urge the international community again to stop talking about this as if a fair trial is possible, and to accelerate the efforts to get Paul Rusesabagina out of Rwanda and back home. Want to thank everybody for their time and turn
Brian,
it back to Kitty. Yeah.
Before we close out, I actually want to take us back in time to 2010 and 2011. As you recall, there were many accusations made by the Rwandan government against Paul Rusesabagina in the international media. They were accusations that were eerily similar to the accusations that are being made today. We were able to take those accusations and refute them, and say and show that they were false and that there was no truth to them. The Belgian government and the United States government rejected those false allegations out of hand. They never took any action on them. Is there any reason at all to believe that any of these allegations being made against Paul are any more true than the false allegations were that were leveled in 2010?
None whatsoever. Paul Rusesabagina is simply the poster child at the moment for what the Rwandan government does to anyone who speaks out against them. Kitty, you're talking about 2010. In 2010, President Kagame was running for office again. He eventually got 95% of the vote. There was a presidential candidate who came back from exile, Victoire Ingabire, to run against him. And Paul Rusesabagina was in the diaspora in the US and Europe, using his voice to talk about how unfair that presidential election was and to talk about Kagame's human rights violations. And the Rwandan government responded by attacking Paul. They made up attacks on a regular basis. There were hundreds of articles in the Rwandan press about Paul during
They
that
attacked him
time.
particularly. They said he was committing terrorism with FDLR.
Absolutely.
And that he had wired money on Western Union.
Yeah,
and
it was,
all of that, Brian.
Yeah, it was completely false. We had evidence. They produced Western Union receipts. They were falsified. Paul's been accused multiple times, as have other Rwandan dissidents, of being a part of FDLR. This is the group of Hutu military and Interahamwe militia that committed the genocide that was behind or backed by the Hutu power movement. Paul has no relations with this group. This is the group that went after Paul. This is the group that attacked his family during the genocide. Paul has a mixed Hutu and Tutsi family. That's anathema to the FDLR. This is the group of people that caused the horrific events in 1994 that led to the movie Hotel Rwanda, when Paul sheltered both Hutus and Tutsis. Paul and the FDLR cannot stand each other. And yet the Rwandan government wants the world to believe that Paul has some connection that simply doesn't exist to the FDLR. That was 2010. Those allegations continued over time. Now it's connections to another group that Paul is not connected to. Now it's suggestions that Paul is financing another group that he has not sent money to. There is no evidence out there for any of this, and these are the same old allegations over and over and over again.
So any time that you might see written in a newspaper or a blog or anything that you see that Paul is being tied with the FDLR, you should probably ask yourself questions about that journalist's motivation and where those questions are coming from.
Absolutely. It's a case that the Rwandan government has a number of friends, small number of friends in the international press, who echo the propaganda that comes out of that government about anyone who is a dissident, and who support their message that the current Tutsi government is good and all Hutus are bad. This is ridiculous. This separates people, and it is a part of the human rights problem in Rwanda.
I think that's probably a good place to close it out for today. Thank you all very much for joining us. As we get information about Paul's situation, we will update you. And thanks again for tuning in to hear about the lack of human rights in Rwanda.